Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. My name is Chief Justice Mark Green. Joining me on the panel for the first two Zoom hearings that we will be conducting this morning are Justice Peter Rubin and Justice Gregory Massing. Following the completion of the hearings in the first two cases via Zoom, we will resume the session in courtroom 4. At that time, there will be a panel change for the third case on the list for hearing. Following the hearing in that case, we will continue with the current panel for the remaining 4 cases on our list for hearing. The first case on our list this morning is case number 2021 P268, George Lavity versus Judith Ellen Petrus and another. Mr. Hamilton, you may begin.
Good morning, Mr. Chief Justice and members of the court. And may it please the court. Attorney Judy Petrus was appointed by the Committee for Public Services Counsel as screening counsel to determine if there was a reasonable likelihood that George Labadie could benefit from a lawyered post-conviction proceeding. Attorney Petrus, who is a well-experienced and seasoned attorney, who indeed has appeared before this court many times, both in her role as an assistant district attorney, as well as private counsel, undertook an exhaustive review of Mr. Labadie's case. Mr. Labadie, as you remember, had been convicted of counterfeiting and some level of embezzlement by the appeals court. He obtained a further appellate review. The Supreme Judicial Court reduced the embezzlement charge and remanded it to the Superior Court for sentencing. Sometime later, Mr. Labadie requested that CPCS appoint screening counsel for him. And when they did, Attorney Petrus undertook an exhaustive review of the case, which, as you know from reading the brief, included not only the trial, but I believe something like 5 volumes of the suppression hearing, and also interviewed a number of the attorneys who had previously represented the defendant during the course of those criminal proceedings. On January 5th, of 2017, as
can I ask you? You mind if I just step in and interrupt? You know, we're familiar with the facts, but let me. You since you're giving us the facts. You mentioned that she spoke to other counsel for the defendant. Did they have an attorney-client privilege that they were waiving by speaking to Attorney Petrus, or was she an attorney and they were all jointly representing Mr. Labadie?
I believe that as attorneys for Mr. Labadie in the past, they continued to have an attorney-client privilege. But I also recall a case in the appeals court several years ago that said when an attorney is sued for malpractice, all of the previous attorneys who were involved in the litigation, that attorney-client privilege is waived. So
yes, Mr. Hamilton, the conversations that Judge Massing is alluding to all took place before any malpractice action began.
That is true, and that may be.
So just going back to his core question, you said that the attorneys who previously represented Mr. Labadie were still operating within the attorney-client privilege. To the extent then that they spoke with Attorney Petrus, they either must have refrained from disclosing any privileged material, or if their conversations included privileged material that otherwise would have been privileged, then somehow she must have been part of that attorney-client relationship.
And I think we would all have to speculate as to what those conversations involved. I was not privy to them.
Okay, Mr. Hamilton, can I then ask you? Mr. Labadie also spoke directly with Attorney Petrus. Were those conversations privileged in your view?
Yes, they were.
Okay, so how could there have been no attorney-client relationship?
If there was an attorney-client relationship, Your Honor, it was a very limited one.
But there may have been one, but it was limited. That's your position?
That is my position.
So for limited purposes, he was her client.
For those very limited purposes.
Okay, so now let's keep going. Let's say that for those limited purposes, and I don't know what the scope of that would be, although I have some thoughts on it. Let's say she committed malpractice. Let's say, I'm not saying that's what this is. I'm not evaluating the merits. But let's say someone with a limited scope like that committed malpractice. We have at least one case where someone who was not yet hired committed malpractice by losing some papers and not filing something within time and not responding to the client. And that was, I think, upheld as a malpractice claim, I think. Would her statements that were part of that malpractice, if there were any, would those be subject to the litigation privilege?
I believe they were, Your Honor, because if you take a look at the restatement of torts, I believe it's section 586, which was quoted in the 1976 judicial court case of Schreiber, which was more or less one of the seminal cases here. The court clearly said that the absolute litigation privilege extends to preliminary matters, preliminary to litigation.
Okay, so now let me ask you this. Imagine this hypothetical. Two lawyers are working on a case together representing a client. They're inside a firm somewhere. They're being paid good money to represent some client. And the client has a very good claim. But the associate turns to the partner and says, this claim is not a good claim. This claim is not worth bringing. And they don't bring it. And that lawyer was completely wrong. Didn't even bother to look up the law. Totally wrong. Committed malpractice. And later, the defendant or the client sues for malpractice. And he says, when the associate turned to the partner and said, this is not a good claim, that was malpractice. Is that statement protected by the litigation privilege?
I can understand that that situation, the absolute litigation privilege may not be used to protect an attorney under those circumstances there from a malpractice case. But let me get...
So why is it available here? You may win the malpractice claim on the merits, but isn't the allegation the same? A statement made by this lawyer to the other lawyers who might or might not have represented Mr. Labadie was malpractice. So, and this is an interlocutory appeal. Because of the litigation privilege, you're being allowed under the doctrine of present execution to come here to argue that point. Why isn't that the end of the matter so far as we're concerned?
Let me go back to your example and rethink it or rephrase it a little. The essence of at least a defamation claim is the third party. Here, the disclosure is only being made within a law firm, essentially one unit and not a third party. And if the court were to decide there was no publication to a third party, then the litigation privilege absolutely litigation privilege.
Oh, okay, but you get that. I think you might be putting the cart ahead of the horse here, right? The allegation is that the statement was made. It may be that at trial, someone concludes something, and on the basis of the litigation privilege, someone wins. But I don't understand why you would get dismissal at this point when we don't even know enough about the relationship. And there may be fact questions that have to be answered to understand better whether this is a third party or the same party.
Well, I think at this point, I have to, in order to fully state our position with respect to the absolute litigation privilege, we have to look at attorney-client and also legal malpractice law and the various elements of legal malpractice law. And as a precedent to duty, breach, causation, damages, one has to be in what I would now characterize as a full attorney-client relationship. And our position here is that Judy Petrus, as an attorney retained by CPCS to evaluate, make an objective and honest evaluation as to whether Mr. LABADIE had a reasonable likelihood of benefiting from a post-conviction lawyered proceeding, had a duty, CPS, that was her primary duty.
I'm sorry, I don't know what that means. She's not CPCS's lawyer. She's hired as a consultant to help them with something that's internal to them. They don't have to hire her. They could have an in-house lawyer do it, right? And instead, they've hired a consultant. But that doesn't make her, the consultant, their lawyer. It means that they've hired someone to join their team and help them figure out whether this is worth taking on. A private lawyer could do the same thing. Could say, oh, we have so many cases coming in. We don't know which ones to take, and we don't have the time to screen it. But luckily, our friend from law school who has a practice in his living room is great at this. We'll hire him. We'll give him $250 an hour, and he can look through all this stuff. We wouldn't say that person is their lawyer. We'd say he's part of the team now.
But she was a private attorney, and if you look at the record appendix, Judge, the policy that's set forth by the CPCS with respect to hiring private counsel to do the screening, that essentially, in my view, and in Attorney Petrus's view, is retaining her and paying her to give CPCS, not Mr. LABADIE, an objective evaluation.
That's not legal advice. That's a business choice or something. It's not legal advice to CPCS. CPS.
I believe it's legal advice because if you look at the letter, Your Honor, that she received from CPCS, she is supposed to look at the merits of the case and determine whether there has been a miscarriage of justice or whether there are meritorious issues that ought to be brought before the court.
Mr. Hamilton, if I may, I'd like to take us back to the analogy that that Judge Rubin framed in his as he began this line of questioning, in which a member of the legal team, the associate, advised the partner that there was no basis for a claim. How would you distinguish this paradigm from that one?
Well, the major distinction, Your Honor, would be the fact that there was no other lawyer doing this work except for Attorney Pietras. And the only distinction she was required to do by the appointment by her counsel, by CPCS, was that letter of January 5th, 2017, in which she provided that evaluation. Here, that evaluation went no farther than CPCS, except for the fact that Mr. LABADIE received a copy. And it was a result of that recommendation. And it's only a recommendation because, as put forth in the policy, CPCS is independent. They take the recommendation into view, but they make their own independent decision as to
But I
whether.
thought you just said that she was the only person conducting the evaluation.
I did.
If she's the only person conducting the evaluation, on what basis would CPCS act otherwise than to follow her recommendation?
They would look at the same materials, just as your honors today.
But I thought you said that they do not do so.
I'm sorry?
I thought you just said that they don't do that she was the only person doing it.
No, she was the only person doing it, Your Honor, as opposed to the scenario which Judge Rubin sketched out, where there was a partner.
Right. So that presupposes that CPCS will not conduct an independent review.
No, I believe they may and they do. And it's simply an evaluation. It's probably not a whole lot different than my standing here in front of your honors this morning and making a recommendation as to how this case should be decided. You are going to make an independent evaluation. And I'm sure that
your time is just about up, but I have two, what I hope are quickish questions. First of all, am I correct that you don't represent CPCS? CPCS is not a party here, and Ms. Pietras has not impleaded CPCS. Is that right?
that is correct.
Let me ask you this. This is sort of a hard question. I apologize for doing it after your time has run out. In Commonwealth v. Francis, the SJC has said that if the screening lawyer gets it wrong, the client may have waived, or not the client, the defendant may have waived their right to bring something. That's what Francis holds, right?
Francis is a long case. I forget all of the details, but I'll take your honors.
Well, the part about it that seems important here is that a screening lawyer in that case did not come forward with a recommendation to proceed. And that is one of the bases on which the SJC holds that a claim is waived. And my question is, if the action of the screening lawyer can waive the defendant's right to do something, doesn't that mean the screening lawyer is the lawyer for the defendant, at least to that extent, and that there must be an attorney-client relationship?
Well, that was the whole point, Your Honor, of the CPCS writing that amicus letter to the SJC once Francis filed a motion for
I
reconsideration.
agree. Francis may be wrongly decided, but that's the law right now, isn't it?
If that, I understand that that's your interpretation of the
Well,
law.
Mr. Hamilton, I think you also need to acknowledge, do you not, that when we are searching for guidance on what the law is, we are to look to the opinions of the Supreme Judicial Court in preference to the positions extended by CPCS in advocacy before the Supreme Judicial Court.
I understand that, Your Honor.
Okay. I think we'll leave it there. Thank you for your presentation, Mr. Is it LABADIE or LABADIE or Lavity?
LABADIE.
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 You may begin.
Yes, sir, I'll be brief. Okay, when they held the Rule 56 here, and that was just to determine if there were material facts in dispute and for it to go for a jury to decide. I believe we met that burden at that hearing when Judge Layton made that decision based on the facts and evidence and sworn testimony before him. One of the part of the evidence was a letter I received from CPCS after requesting an attorney for a new trial motion. They asked me to provide them with the issues that I believe were wrong in my trial. Based on that information, on July 27, 2016, I received a letter from CPCS marked as Exhibit A, I believe, in my appendix in the brief before the court. And it says simply, name of notice of assignment of counsel, date of assignment, name of person whom counsel is assigned, George LABADIE, that would be me. Attorney assigned, Judith Ellen Petrus. So they have assigned me her as an attorney. Then I received a letter from Miss Petrus, an introductory letter. And in part it reads, "I'll tell you as I tell all clients. I now specialize in post-conviction work for criminal defendants." And she goes on to say, "It is more efficient to communicate in writing as I am frequently out of the office or in meeting with other clients." Then at the end, dated June 16th, 2017, I was requesting documents from Ms. Petrus. She never provided those documents. I contacted CPCS for these documents. General Counsel Lisa M. Hewitt. Again, letter dated June 16, 2017. Ms. Hewitt, General Counsel, replies, "I received your letter dated June 12, 2017. CPCS is unable to furnish you with the detailed billing records you have requested. This information is something that should be contained within the client file in the possession of your attorney. Please contact your attorney for the detailed record you seek." Her address, and she gives me the address and the name Judith Ellen Petrus. Now, beside that, Miss Petrus met with me, I believe it was in 2016. We had a 4-hour conversation regarding my case, a privileged conversation. At all times, we had numerous correspondence through the mail, probably at least 30 letters, which is in part of my appendix before your court. I mean, at all times, I truly believe 100% that Miss Petrus was acting as my attorney when I shared many hours of confidential attorney-client privilege information with her. And I mean, that's the crux of the case, that I believed that there was an attorney-client privilege relationship. And I had no reason to believe otherwise based on the letter of assignment of counsel from CPCS, Ms. Petrus's introductory letter, and the letter from General Counsel from CPCS all support that. I mean, who would not believe that she's acting as my attorney? I mean, there was never any doubt.
Can I ask you a question? When
Sure.
then assuming she's your attorney, you have some defamation claims. Who did
Yes,
she
sir.
who did she defame you to?
She defamed me in, I believe it's Exhibit A4. If you read that exhibit, she published a 10-page document with numerous allegations in there that she was negligent in doing because she never verified the things that she put in the letter. For example, in that 10-page document, she states that she was told by another attorney who she was unauthorized to speak to, that the attorney found I had things put on my query that didn't belong to me. She claimed in this document that the lady had the police reports coinciding with that claim, but there wasn't any police reports because it didn't happen. It never existed. But she never requested those documents. She made numerous statements in that 10-page document that were totally untrue.
So my question, the answer to my question, the only people that those things were communicated to were the folks at CPCS who were deciding whether to oddly appoint you counsel or not.
Well, sir, I'm not sure who she communicated them with. I don't know.
Okay,
But,
thank you.
we'll find that out in court before a jury under sworn testimony and evidence with the discovery and everything else.
Well, but just to be clear, Mr. LABADIE, the letter, the 10-page letter that you are describing is the letter dated January 5th of 2017 addressed to Donald Bronstein?
That's correct. There was another letter in December also. I don't have I believe that was December 10th. That might have been December 10th, 2016 or 2000. I'm not sure. There was 2 letters.
And to whom was that letter sent?
I believe that letter was addressed to the same parties.
Okay, so that letter went to Mr. Bronstein as well, to CPCS.
I believe so.
Anything in the record to suggest that the content of that letter was communicated to anyone other than CPCS?
Not that I'm aware of at
Okay,
this point.
okay. And do you allege that it was sent to anyone else?
At this point, I don't, Your Honor, because I'm still in the discovery process.
All right. Is there anything else that you would like to tell us?
Let's see here. Not really. I don't believe so, no. Other than, I would like to, be before the court in front of a jury and let them decide the facts of the case.
All right. All right. Are there any further questions from the panel?
No.
Hearing none, that will conclude the arguments in this case. The matter is submitted, and we will proceed to our hearing in the next scheduled matter. Thank you both.
Are live and on the record.
All right, we continue our hearing with the second of our Zoom hearings this morning, case number 2021 P224, Giles Kennedy versus Horsefoot Harbor, Inc. and another. Mr. Crowley, you may begin.
Good morning, members of the panel. May it please the court, Chief Justice, and the members of the panel. I represent Giles Kennedy. Mr. Kennedy, back in September of 2015, while spending a lunch with a bunch of friends who just come in on a boat to the Sundancers restaurant, shortly after arriving, was seated on a plastic chair. And shortly after sitting in that plastic chair, he went to move it back, and one of the legs on the chair bent 90 degrees, and he was thrown to the ground and injured. He mentioned this immediately to his server, who recognized it and indicated that he had told the management. He replaced the chair, and shortly after his lunch, he went to the management and told the manager what had happened, and indicated that, in fact, he had hurt himself and was in pain, and thinks he may have asked him to retain the chair. No further communication was made with the restaurant until our office was retained in the early part of the following year, when we did send a notice of claim that, as my brother has pointed out, was very generic and did not even mention the chair. Another letter was sent shortly after that, a couple months later, similarly generic. The two issues before the court are the question of whether or not there's enough evidence to proceed to trial generally on a res ipsa loquitur claim position, and also a question of spoliation. The trial court heard argument on summary judgment motions and ruled unfavorably, obviously, to the plaintiff on both matters, indicating that there wasn't sufficient evidence to submit the case to the jury on negligence, and also indicating, essentially on a summary judgment sort of perspective, that there wasn't sufficient evidence of spoliation. So,
Mr. Crowley, if
yes,
the
sir.
case were to proceed to trial, and as you place it on a theory of res ipsa loquitur, it would be open to the defense to suggest to the jury that your client was partially responsible based on his own conduct for the collapse of the chair. Is that correct?
Well, I certainly agree that comparative negligence would be available to them. I'm not sure there's much evidence.
And in that event, on the state of the available evidence, at least on the state of the evidence that we anticipate would be available based on the summary judgment record, how would the jury evaluate any question of comparative negligence without engaging in speculation?
Well, frankly, Your Honor, I think that the question of speculation on the comparative negligence would be much easier for them to evaluate, because they'd have Mr. Kennedy's testimony. They'd also have the testimony of his 3 or 4 lunch mates to describe what exactly happened when he fell.
Well, but I mean, let me just pose one possible scenario. Let's say that the testimony is that he was sitting at the table, that he pushed the chair backwards, that a leg of the chair caught on an uneven surface on the deck, and when it bent, it collapsed and broke, and he fell and injured himself.
Well, I mean, based on that, hypothetically, Your Honor, I would think there'd be no evidence of comparative negligence. The way you've described it would suggest to me that it was simply a normal use of the chair, which is obviously an important part of a res ipsa theory. And if the surface of the surface of the deck that they were on was uneven, such that it would cause the chairs that they had supplied to break and fail, then I think it's pretty clearly a strong argument for negligence.
Well, uneven in the sense of a gap, let's say, of ordinary width between planks of the deck surface.
Well, again, your hypothetical didn't seem to contain anything that would, in my opinion at least, suggest comparative negligence on his part. He simply moved the chair back. And if the defendants chose a chair that wasn't capable of handling the normal width gap in the deck planking, then I think that there's a strong evidence of negligence. And as you gentlemen well know, we don't have to prove anything other than beyond preponderance that there's a reasonable inference to be drawn that there was negligence. We don't have to exclude every possible explanation other than negligent
I
one.
understand, but it doesn't have to be a risk that was foreseeable to the premises owner or operator.
That's certainly true, Your Honor, and we would suggest that they chose the chair. They knew what the surface of the deck was. They inspected the chairs daily, and I'm not suggesting, the plaintiff is not suggesting that there aren't possible ways this could have happened that don't involve negligence, but the point is the cases make it very clear that it has to be problems or causes of equal probability where it becomes purely speculative. If we can prove that there's a reasonable inference that it's more likely than not a combination of things that led to negligence, then that's all we have to do.
Am I correct that the defendant has not implemented the chair's distributor or manufacturer?
You are, Your Honor.
Is it too late?
I think that's within the discretion of the court, Your Honor, but it's late in the case, very late in the case, but it's certainly a discretionary matter. It's my understanding, Your Honor, at least on the evidence, and you've seen this a bit in the spoliation materials, that we were not able to ascertain who that was based on what little information we got from the plaintiff, the defendant. I don't know if they have additional information with which they might be able to do
I
that.
thought you were given the name of a distributor or somebody who then didn't respond to requests. Am I wrong?
I believe.
Yeah.
I believe that the response was that the folks that were identified did not have any information about selling the defendant the chair. So I don't think it's clear that they were necessarily the manufacturer of it.
That might be something, that might be a burden on the defendant. That is, if Callahan applies here, then the defendant is able, presumably, as I read Callahan, it says in the absence of an explanation, blah, 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 the jury can infer. Presumably the defendant can put forward some other explanation, but the burden, I would think, would be on them to go and get whatever expert is needed to show that what happened here isn't ordinary use of a chair, or it does, whatever it is. I don't know.
Well, I'm not sure it's their burden, Your Honor, but it's certainly available
If
to
they
argue.
unless they want judgment to enter as a matter of law, if it's a res ipsa case, right?
Well, I mean, I guess I would just say that they can certainly argue that we didn't do a good enough job of persuading the jury that the defendant was negligent, and certainly I would expect that they would, forcefully argue that there were a number of other possibilities, and they might bring in experts, or they might, if they were able to identify the manufacturer of the chair, bring in evidence from them.
So help me with this. It seems to me there must be lots of restaurants with lots of chairs in the Commonwealth. And if it seems to me that if we rule in your favor here, that there could never be summary judgment on a chair collapsing in a restaurant.
Boy, Your Honor, I mean, I have to tell you that I think that you're not far off the mark when I read Callahan and Chorus and Wilson. I mean, to be honest with you, I mean, obviously I'll always be honest with the court, but I mean, when you read Wilson, that's the garage door case. If you recall reading the dissent in that, I forget which justice it was a blistering dissent. I mean, he said that it wasn't just a matter of piling inference upon inference. It was a matter of piling conjecture upon conjecture. And when you look at the two chair cases, I would note that my brother did not, if my memory serves me, really even make an attempt to distinguish those cases, and didn't bring in any chair cases from Massachusetts. I mean, those two chair cases contain virtually no evidence about what happened. They basically just say, in the case of the Callahan case, the chair or chorus, I think it is, the chair broke and fell forward. And there's this issue about their kids playing in the auditorium, but there's no evidence they did anything to that particular chair. And they found a bolt on
there's a loose bolt found or something in that one, right? There's a bolt found on the ground. It's really Callahan where nothing is found.
Right.
Chair just collapses. That's sort of the pure case.
Yes, I agree with you, Your Honor, but there was no evidence that the bolt was on the floor before it all happened. So it could have happened as part of the chair collapsing. And Wilson, the garage door case, I mean, boy, oh boy, you got a lot of people using a door. The judges
that's
accept.
a little different, right? The door is fully in the control of the defendant there. I mean, Callahan is the one I would have thought.
Well, I think, Your Honor, Wilson, the court specifically said that wasn't the case, that the door was used by members of the public, by other vendors coming in and out, as well as employees. It was used regularly by other people, but the control element was certainly met there, because even though there were other people interacting with it, the defendant had the control of the chair and the duty to maintain it and inspect it and so forth, just like the chairs here. I mean, I think if the way I'd ask the court to look at this is if the restaurant owner isn't very highly responsible for providing a safe chair, then we're all at risk. If they can just say, geez, we don't know what happened, you fell. I mean, it's their burden to make darn sure that the chairs they're supplying to people are appropriate. And these plastic chairs, I think we all know from personal experience, some of them are sturdier than others, and they certainly aren't the same as a good, heavy, well-built chair.
Can I ask you a question about the spoliation claim?
Yes, of course, Your Honor.
I don't see the February 2016 letter that's supposed to put them on notice in the record. Every place you cite, you refer to it, you cite to someone describing it arriving or being sent or something. We don't have that letter. Is that right?
Your Honor, I was not focused on that. I think my brother was focused on that because it did not contain a description of what happened. I think it's in the record, Your Honor, but off the top of my head, I can't say where it is. But I will tell you that I know that it simply says that my client has a claim and gives the date on which he has a claim. Does not describe how he was injured, does not describe what his injury was. However, I don't think that that's important to the analysis of the court, because I think the question is whether or not on the day this happened, the chair should have been held. Okay. Certainly, if they didn't have a duty to hold it on that day to retain it, they didn't have a duty to have it when we gave them that incomplete notification or generic notification 6 months later. So the question is not that.
What is it that happened on the date of the injury that you contend put them on notice that they needed to preserve the chair?
Well, clearly the server knew that my client fell because the chair was defective. No doubt it was defective at that moment.
There was nothing in the exchange that took place following that fall to indicate that the fall was likely to ripen into a claim.
Well, I respectfully don't agree with that, Your Honor. My client went and saw the manager afterwards, the owner of the restaurant, in fact, and according to the evidence, the summary judgment record, he indicated that he had fallen, and he did indicate, my brothers argue in their response brief that they didn't, but if you look at where we say he said that he was in pain, I missed the page in the deposition by a line. If you follow it to the next line, he says he did tell them that he was in pain and that he'd hurt his back. And he says he thinks that he may have asked him to hold on to the chair. So I think when you look at the record.
That you send letters and write complaints with no facts in them?
I'm sorry, Your Honor, can you say that again?
Is there a reason that you write letters and file complaints with no facts in them?
Well, Your Honor, I can't honestly answer that question since I've just joined Mr. Noog's office a few months ago. I think it certainly would have been better to have more detail in there.
I think it might have been better too.
Yes, I agree. I don't think there's any doubt about that. But again, Your Honor, on the spoliation question, I just don't think.
I hear what you're saying, but I just, I look at it and it's like, who's supposed to know anything about what's going on from this stuff? It doesn't say anything.
Well, that's a very fair point, Your Honor. So I'd say one thing we haven't talked about because of the structure of the case and the posture of it is, what did they do? We don't know. Okay, whatever insurer was notified immediately after that would have said the same thing, Your Honor, said, what happened? How was this guy hurt? And they probably contacted Mr. Abramson to find out, and they could have contacted Mr. Manoog to find out. And because of where this case was cut off, we
Is there
didn't.
information in the record? This is a partnership, this business. There are two Abramsons, is that right?
There were two Abramsons involved. I believe there was a partnership. I don't know more than
And do
that.
we know that all the records of the business were in the late Abramson's possession and control and were disposed of? Is that?
It's my understanding that he had control of them. I think it was unclear. In fact, they did provide us with some records, but I would point out the case from your court back in April involving Wachusett Mountain excoriated the defendants there for not holding on to employment records. And the time frame of this would have meant that by the time that we notified them of the injury and when we actually made our requests in this case, our production requests, they should legally have had all of the employment records. They did
So
not.
you received no tax forms, I-9 forms, anything like that indicating who was employed at this restaurant during the relevant time period, even though we might be within the time period during which IRS regulations require retention of such records. Is that right?
Your Honor, off the top of my head, I apologize. I know that we were supplied with some information about some of the employees that were working there at the time. I don't know exactly what kind of records we were supplied with. I'll conclude at this point if the court doesn't have any other questions.
Thank you.
Thank you.
For the defendant?
Thank you, judges. I'm going to be brief on both points. The case of the doctrine, the whole conversation as we started and these arguments going back and forth, in my opinion, again, prove the point of the judge's decision, and that is we can speculate, we can engage in a hypothesis, we can come up with the scenarios, but what we don't have is any evidence upon which res ipsa loquitur could be applied.
Mr. Stankiewicz, I read in your brief the manner in which you attempted to distinguish the Callahan case that we were talking about with your brother. And as far as I can tell, other than the fact that it was nearly 100 years ago and the fact that in those days chairs were not made out of plastic, I'm not sure I understand the basis on which you distinguish that case from this one.
Okay, the court said based on all the circumstances of the break. Unfortunately, the court did not go into describing those circumstances for us 100 years later.
Well, in that case, no, but in that case, if they were circumstances that they thought were material to their holding, they would have shared them.
Well, who is to know that? We again, hypothesizing and speculating. But what I wanted to say, Your Honor, that in that case, we dealt with a break. In this case, we are dealing with a collapse. Two different things. There, the break was established. Now, when plaintiff says collapse, what does he mean? It is, again, totally unclear. Did the one leg just loosen up and it was how you call it, just extended a little bit, or whether was something in design that there was maybe weak piece of plastic at the joint, and we don't know.
Were those questions present in the Callahan case?
I'm sorry, Your Honor?
Would those questions have been present in the Callahan case?
No.
Really? Why not?
Callahan, do you think Callahan is still good law?
Do I think? Yes, in its limited circumstances.
Do you think in this case you needed expert testimony?
Did the plaintiff need an expert? Absolutely.
Why didn't they need an expert in Callahan, and why do they need one here?
Well, in a Callahan case, they had a chair, they had a brake, and apparently they say, oh, okay, maybe at that time these chairs were breaking. Maybe there were instances of them being of poor quality. I don't know, metal.
You don't think that it's possible that there's instances of plastic chairs being poor quality?
Oh,
Why
yes,
not?
yes,
I
absolutely.
mean, and you say you don't know
But how
how
can
it
you
happened.
charge
Doesn't the plaintiff here say he tried to back the chair up and one of the legs bent under the chair and it collapsed? I mean, it's easy enough to envision that.
Of course, it's easy to envision.
So now maybe, I take it what he's saying is like in Callahan. If that's, unless the chair was being used in some abnormal way, and that's a jury question, I suppose, chairs aren't supposed to collapse. When they collapse, maybe they're negligently designed, maybe they're negligently manufactured, maybe they're negligently maintained.
Yes, Your
But
Honor.
negligence exists somewhere. And so he sues you, and you haven't, for whatever reason, impleaded the distributor, the manufacturer. He says either you bought a chair that was unfit for its purpose, or you failed to maintain a chair properly, so it became unfit for its purpose, and it collapsed. Now, I understand why you might want an expert under modern law. I could see that. But Callahan doesn't have an expert about cane rings and chairs and what size nail you're supposed to use and, and so on. I don't know, right? It seems, and maybe Callahan needs to be modified, but I can't distinguish Callahan. Seems like the same case.
No, it is not. But let me address few things you said, Your Honor. Yes, any product in this world can fail and collapse. Okay, that's why we have a law of products liability, which allows plaintiffs and eases their burden to prove their cases by imposing strict liability for defective products. But if this court wants to extend strict liability to the restaurant owners, to industry that is already reeling and suffering, can you imagine the insurance cost of doing business as a restaurant when you
might have to actually go out and buy a chair that doesn't collapse. Who knows how much that could cost?
You know how many collapses, Your Honor, there were in this restaurant before this one? Do you know how many?
I'm hoping zero. How many? You tell me.
Zero. Yes.
Okay,
Zero.
so it turns out that your insurance cost shouldn't be very high.
Zero. So
one out of, and how much could that?
Where is the notice? Where do we still give owner of the premises a reasonable opportunity to find a defect?
I'm just bound by Callahan. I'm not saying Callahan is right or is good law now, or that there aren't places, but I don't have the power to overrule Callahan. And I agree with you, it's still good law.
But it doesn't apply here.
A lady sat in a chair and it collapsed. The court said that goes to the jury. And then it also said, what did it say? It said that the defendant could still win. It says, I don't remember. I have it in my notes here somewhere. It said that in the absence of explanation to account for the breaking of the chair, the jury could reasonably infer, under all the circumstances, including the nature of the break, that the failure to discover and remedy the defect was due to negligence on the part of the defendant. That's no more or less true there than it is here, but they let it go to the jury. How the people who operated it.
What's the nature of the break? I'm sorry, I didn't mean to interrupt.
The nature of the break there, I don't know. The chair collapsed, right?
So we're going back to the fact that just accident happened and the product collapsed.
That's what they said.
Where is the evidence? Where is the evidence in this case of nature of the break? It wasn't even a break. It was leg was bent.
Okay, so nature of the bend. There's the evidence. It's in the testimony of the. Now the jury could find he's lying, or they could find he's really overweight. Maybe that's I mean, I don't know. Let me ask you about spoliation for a moment. Two questions. First of all, he says in his, I think, deposition, I said I was in pain and just wanted to go home. Why isn't that enough so that there should at least be a hearing before the judge about whether you were on adequate notice, I'm in pain and want to go home, that maybe you should keep the chair?
Well, because that's, I'm in pain and I want to go home. After what? After eating the lunch?
No, after falling because the chair broke.
Well, what did he do? What did he do after his accident? He was given a new chair. He sat there with his buddies. They had their meal, and then when he was going to go pay the bill, he asked for a manager, and that conversation occurred that you got to move that chair essentially from the deck. You got to look after it so it doesn't happen again. What pain? If he asked for a medical help at that time, the restaurant would oblige immediately.
Okay, let me ask you about the employment records. They can't find some of these witnesses who were employed by the restaurant, and they say, how come you threw away when after Abramson died, when you were on notice of a claim, you threw away business records? I don't know if I don't mean you personally, but whatever, his relatives or somebody threw away business records. Why is that not a good basis for either a hearing or a spoliation claim? Presumably the business was required by the IRS to maintain certain records with respect to who its employees were. And I understand what the restaurant business is really like, but that doesn't mean they're not required to have I-9 forms for everyone who works there, keep them for 3 years and so on. And none of that was available or turned over. If it turned out that they were thrown away, why would that, after there was notice of claim, why is that not spoliation, giving rise to some kind of inference maybe?
Let me answer that with a couple of points. The first point, Your Honor, is that this issue was never raised in appeal, and this court in the past would not address issues that are not raised on appeal.
I thought the records, the absence of the records, I thought was raised below. You're saying it wasn't raised below, or it wasn't raised before us?
Both courts. Second, we did provide information on all wait staff that day, and that's why my brother was able to take 8 depositions in one day. I don't know what I actually don't understand what is being said here. We provided all information on all people that worked there, and he took the depositions. There was only one person, apparently, who worked there for a week or less than a week. And there is testimony as to that in a deposition of Mary Abramson, who was 30B6 deponent. So that is a absolute non-issue. The other thing is, who knows and who established here how long these records were kept or not kept? And what would it even mean to this court if my client did not comply with IRS regulations in a negligence case? Nothing.
If in discovery you don't turn over records that you have a legal obligation to maintain. Now, I agree the IRS piece of it hasn't been raised here. That's I'm raising that, but presumably, if you have to maintain records by law and you throw them away anyway, that might be some evidence of recklessness or negligence in maintenance of records that might have been useful to the. But I do hear you saying that you turned over information about who worked there. I mean, we'll have to obviously look through and see what documents it is they say they don't have.
And we turned over also information where we purchased the chairs. If my brother, served subpoena and received, we don't have any information, and didn't follow up on that, didn't take the position of that owner of that store or owner of that distributor, that doesn't shift the burden on me to look for that. Those chairs were good. They were good, and we continued to use them. That was one.
How do you know that? There's not even a picture of these chairs in the record, right? How do you know you continued to use the chairs?
But that was the testimony.
There's testimony that
from the servers, and there was a testimony from the management. They continued to use them without any issue. This is such an isolated accident, and years-old principle that we abide in Massachusetts is the occurrence of weird accidents is not evidence of anyone's negligence. We can think, we can talk, and we also argued in the lower court, and we're saying now, these types of cases are appropriate for products liability action. I'm not saying my brother cannot file his negligence action, but the court should not convert the negligence action into products liability and allow the jury to speculate about why this chair why this chair collapsed.
All right. Thank you, Mr. Setkovich. I see that your time has come to an end. That concludes the argument from both sides in this case. The matter is submitted. We will recess briefly and resume with our hearing in the next case in courtroom 4. Thank you.
Thank you, Your Honors.
Thank you, Judge.